Let's see. Who's the
Mr. Trusher.
to
Yeah, that's the one that I
start
got.
a meeting?
Yeah, good. Yep. Yep.
This is no one can you hear? Ready to get started? Let's call this meeting to order at 6:33. Any changes to tonight's agenda?
Yes.
Sir.
Before we get into Kevin's business, I'd like to go back and I'd like to talk about what happened at the select board meeting
Okay,
in related matters.
okay, we'll do that once we get through the housekeeping. There were no minutes per se to the April 5th
It was
meeting.
from March, right? There were no minutes for the
Do
April
we have to
meeting.
approve March?
Yeah, I thought we had approved March last meeting, but we didn't, we ended up adjourning before conducting any other business before the minutes, and stating why.
Yeah, but did we approve?
Yeah, I thought we had.
Did we?
The town plan status, so why don't we open with,
If you want to open the town plan stat, well, no. Excellent point that I didn't understand at first. Since the select board meeting, I spent the last, 30 hours trying to figure out what it was all about and the problems that would cause us and maybe the town.
Is that how you hurt your arm?
No. I may use it elsewhere.
There's holes in his.
I don't have a cast on it yet, so I'll wait for the cast. I really wanted to understand why the select board, not necessarily that they didn't agree with us on a particular subject, but really why they were taking the course that they were doing. Talked to a lot of people that were in different loops. And since I sent out something earlier, I don't have enough copies for everybody, but this is a refined copy of what I wrote, and I'm happy to read it. It involves Kevin, Two Rivers, town manager, select board, and us.
Take us through it.
I am.
Take us through it.
There's one. There's one if you can share. The best thing for me to do is read it. You'll have to, I haven't got,
I'm cool. I can just listen.
oh good.
Yeah, thanks, Lefty.
My voice is going already, but I'm just going to read it straight away. Hey Kevin, if you can hear me, it involves you too.
If it involves the town plan, it does involve. That's okay.
Okay. This is, for me, as a planning commission chair, and it's entitled "The Impact of the Weakened Heartland Town Plan without an active land use ordinance." In the last 24 hours, a number of serious issues have arisen concerning unpublished last-minute changes in the Heartland Town Plan. Approved, yes, and it's, by the way, that it's a 152-page document, and its forthcoming adoption by the Heartland Select Board. This was discussed at the Select Board meeting last night, May 4th. The Select Board had made nominal changes to our town draft, then sent it to Two Rivers, Ottaquechee Regional Planning Commission for comment. TRORC, Two Rivers, then edited the document for SOB officials, Select Board officials, changing virtually all the definitive shalls to, let me see, shalls, as we did so in our draft. This was to have, oh God. Hey,
You missed it.
Hey, would you do me a favor? My voice is gone, and I don't have my glasses. Would you, and could you edit it as you go?
Do you want me to read it?
Yeah, if you will.
Okay. All right, so the select board had made nominal changes to our HPC draft of the town plan, then sent it to Two Rivers for comment. Two Rivers then edited the document for select board officials, changing virtually all the definitive shells to less stringent conditions of should or limited.
Hey, when that statement's unclear to me, are you saying they were instructed to change, or did they change of their own volition?
My understanding was Two Rivers suggested that those changes be made in the select board.
But we had already discussed that.
We had already
weeks
discussed it.
before.
Yeah, we had made a conscious decision the other way, so.
Previously, Two Rivers had strongly advised the HPC to use shall, and we did so in our draft. That was to have the consequences of making our town plan very precise to those Act 250 officials reviewing and acting on an Act 250 application. Neither Two Rivers nor the select board told us of these changes, nor gave us a copy of it before the select board meeting. Many select board members did not know about those changes much before the May 4 meeting. Our HPC coordinator with the select board didn't get a draft of the proposed amended plan at the meeting and had to read a select board member's copy. The town manager did not post the Two Rivers altered town plan until 10 a.m. this morning, and it didn't contain the red lines to let anybody learn of what was changed. Select board members said it would be confusing for the public to hear the HPC versus the select board versions to compare. It is customary to provide a before-after red line version, apparently in response to avoiding such confusion. The select board is planning, as of last night, to vote on the weakened town plan within a month or two. If that happens, any Act 250 project noticed if and before any ordinance is passed will do so with poor chances of adequate review and appropriate changes or revisions to comply with the town plan. Someone conjectured, only half joking, that without a strong town plan, a used car lot could be built beside Esquib Bog, or a commercial project could be built in or near your own backyard. The town of Heartland failed 100% out of 4 tries to pass an ordinance. We on the Planning Commission are aware of this reality and estimate it will take much longer than a year for any ordinance to become lawful. Its creation is just now underway. Many drafts are needed. Meetings will be held separately by the HPC and Select Board with Two Rivers oversight. There are rounds of public comments and likely legal challenges. Should the Select Board pass their weak version of the town plan now, before there is an ordinance, the town will have no protection against untoward Act 250 projects. The best path forward is for the Select Board to pass the HPC town plan version and change it later to complete with an ordinance if that even or ever happens.
Let me ask a question because I want to be certain of my understanding. We completed our project and we turned it over to the select board as we were required to. The select board isn't required verbatim to accept it verbatim, correct?
Yes, that's true.
So, I mean, what that's stating sounds like it would be expressed at the town hearing, right? Unless we wanted to negotiate, but we don't have any real standing to affect a reversion back to the state we had.
Well, their next step is to hold hearings.
Correct?
And that's our standing.
And we can go to the hearings and
Exactly.
say, this is our concern. And I think the way we left it at the select board, at least my understanding, John, correct me if he thinks it was otherwise, is that we were sort of invited to do that if we felt strongly about it.
Okay.
So
That's
it's
exactly
far from
right.
over, but but at least at the hearing, those were all recorded, that'll be, if we take the position tonight that that's gonna be our position at the select board hearing, then that's what we'll do.
At that hearing, do we speak as members of the community or as the planning commission?
I think we would identify ourselves as planning commission
Yeah,
members,
yeah,
and
yeah.
we can represent that the version that the select board has held up for hearing is different than our version that went to hearing earlier, and we're concerned with the changes that were made.
John, I would offer that we could do it multiple ways. One, we can draft something tonight out of this meeting that can be presented at that open hearing. And two, we can also speak as individual residents of Heartland at that meeting. We don't have to identify necessarily as commission, although it probably makes some sense to say that and say we're speaking as an individual. But I think we could, if we wanted a unified voice, we could construct some sort of a statement that could be made.
Well, I just feel that would be more effective, more powerful if you spoke as the commission. Do we understand? I mean, it wasn't a random act. There was a reason.
Yes, and there's arguable reasons. It's not like it was done
What are we talking about? What arguable reasons for what?
For the change.
for the
making
changes. Yeah. So it's not like, it was off the wall what they did.
Right.
We have a philosophy, or I think you could boil it down to the confidence that the parties have about the timing and the ultimate success of an ordinance.
100% agree.
And
Those
so,
I would
so
agree with those two.
if you're confident that there's going to be an ordinance, the town plan should only be directive, but not prescriptive. But if you are worried that there's, not going to be an ordinance, we're back to where we were for the whole history up until today.
But those two objectives are not necessarily at odds with one another. I mean, if you view the town plan as a gap document until such time as ordinances are passed, I don't see that whatever it's.
We might not disagree with the changes they made if we can project into the future when we are at a safe landing spot. It's the time to get from here to there and have all the pieces fall in place by that ultimate, that to me is that gap or the uncertainty of even seeing if ordinances would even pass muster. Having said that, and help me on this one, John, if you can, or Phil, I don't know if the select board is required to go to a town vote to accept ordinances, or if after the open hearings they can decide on accepting them as written without going to a town vote.
Correct.
So,
Did that answer your question?
I think, yes, it does.
Okay.
I'll zip it on that one.
But you know what's missing in this conversation? Does everybody know what they changed, the details of it?
No.
Okay, I happen to find probably the only non-select board copy of the changes that were made, redlined ones. And I read through them. I was hard pressed tonight, and I noted what they were. Some were reasonable, some I personally thought were unreasonable. But I think we should all look through to see the critical items that they changed. And I would say some are good, some are a bit willy-nilly. But that's their business. But we need to see it before
June 1st.
before it is. So what I did was, I was so rushed that I made a copy of some of the changes, but I forgot to do it in color. So we're about as blind as a bat right now. I'm happy to send it out to you later. But that's one of the issues, is to see what they changed, in which case we can have a reasonable conversation with them. Well, maybe you shouldn't have done that, or hey, this is the consequences. We know the consequences because we're the ones at Act 250. Select board members hardly go to Act 250 hearings. We know what we're up against when we're there. And you gotta be dead on there. If you have wishy language, the District 3 commissioners will blow you off, just like they did at the Sunnymede. So there's more to be learned. But the bigger problem is, and that I think I would even use the word Gallsby, is that why didn't the select board at least give us a copy of what they did? I had to find it elsewhere. I had to dig for a while to find out what the red line changes were. I know now, and I'm happy to share them with everybody.
So we'll look at those. When the changes were discussed on Monday, was there a simple, straightforward explanation for why the decision was made, why it's better for the town to have amended the language and used that?
My understanding was that there was a feeling that if you have prescriptive language in the town plan, that could get in the way of an ordinance or be inconsistent with an ordinance that you would pass later. So the town plan should be suggestive of the direction you want to go. And then if you want specific prohibitions, you take care of those in ordinances, which is.
Yeah, but we had this discussion.
We did, yeah.
We had this discussion.
But first of all, there's nothing wrong with that position. I mean, that's
nothing.
correct, right? If you think to me, the whole thing stands one way or the other on the confidence you have.
My recollection was, and we talked with two members about this, was that the plan did not it didn't present a hurdle or an obstacle to subsequent ordinances. Yeah, it's definitely a direction.
Well, we don't know what they are yet. So
That's exactly right. And so it wasn't like the die's cast with the town plan. That was my takeaway, because we spent a lot of time discussing that. We wanted it to be prescriptive. We did not want it to be obstructive in any way. And I just remember that was the conclusion that was
We were playing with different money than the select board has, and I don't mean that in the literal sense of budgetary money. All right? They have more chips on their side of the table than we do. They can predict with greater certainty the future than we can. And I think that was my assumption, please forgive me if I'm wrong. My assumption is that they see an end goal that they believe that they can achieve, and they believe they can achieve it in a time frame that will allow the soon to be approved, revised, if you will, town plan will be protected enough, because there will be some kind of ordinance out there that will support it. They can control that. That's what I interpret.
Yeah, but again, I go back and
we've done our job as an advisory group.
You're right, but that means that the town plan, as we put it forth to the select board, could cause harm. That's my takeaway from that statement.
By harm, you're talking about Kevin's opinion, supposedly Kevin's opinion, that in fact, if we have strict things in the town plan that don't agree with or aren't made possible by the ordinance, then you get into trouble.
No, I'm not talking, I'm talking about it would hinder the select board's ability to implement the ordinances they want to. But that's the reason you would change it. is if you thought it was an impediment to achieving. I don't see that the timeline's at all relevant. That to me means nothing. It's, if you've done something that's gonna hinder the outcome that you can foresee and that you want, yeah, I'd listen to why we made the changes and why it's in the town's best interest. But if it doesn't do that, I don't see why we change it.
We didn't change it.
Well, what I mean is the collective we.
The collective we has a few more irons in the fire than we have that would allow them to feel comfortable to make that change. And they're just gonna change it now instead of worrying about revising it later.
That's guesswork.
Yeah?
I would add one other thing. But in my most humble of opinions, both the select board and to some extent the regional planning commission has made our job much more difficult because you didn't share information with us. We had to find out on our own. I was shocked when I heard that Two Rivers, I don't want to say willy-nilly, but just did what you asked them to do. We see Kevin all the time. We didn't have a clue what was coming from them. And you and the town manager never showed us red lines, and we had to dig it up. I mean, there's 7 of us supposedly, and you're not making life easier for you. We're all supposed to be on the same side. I'm fully satisfied. I'm not done. I'm fully satisfied. I'm fully satisfied that the select board can make whatever decisions they want with respect to the town plan. I have no issue with that whatsoever. But when we go back and forth trying to get this, work it out somehow, how can we do it if we don't know where the playing cards are?
I think that point should be lodged. We did. I don't see a lot of benefit though to adjudicating it here or arguing it. I mean, because we can't change anything. It's a very valid point to make that it does seem like I don't see any harm in having advised us. But so now what are we going to do? Dave?
Does anybody mind if I speak?
Well, to me, I'm not going to direct it at you. Usually, when we're having a conversation going on the select board, is that we should keep it amongst the minutes or the officers of other organization and let the audience speak later. No offense.
None taken.
That's
Okay.
That's so we should read the document. We should understand the changes. We should listen to explanations about the changes, which I think is pretty clear right now. What else are you suggesting? Because I don't see that we're taking, it's fine if we want to speak at the hearing as either the planning commission or as townspeople, but we're not doing anything in the interim.
No, if we,
Other than preparing.
yeah, I mean, if we think that we should speak at the hearing as the planning commission, we should take a vote on that is going to be our position. Otherwise, any of us can go to the hearing and testify as citizens or ask questions as citizens. But I think if we're
We
going to
spent a lot of time putting that damn document together.
So that's the argument that we might want to take a position as a hearing.
I think we do, because I definitely recall this discussion in great detail. We thought we were doing the right thing. We thought we had misstepped by removing that language previously. And the consequence was the Sunnymede decision. So I do think it's warranted. I mean, what do we think?
Do you want a motion?
Well, does
Well,
anyone want to
you've
say?
added a third variable. the third variable is the process. And I'm not sure how that process completely adds value to any open hearing. I would,
What process?
the process of informing the planning commission, the select board, informing the planning commission that we're gonna make change. But that's part of what I'm hearing here is that wasn't part of it. I don't wanna fight that battle in the open hearing.
That is a discussion between.
That's another
the two
conversation.
bodies, and it's
100%.
really no need to be
Yeah,
anywhere
Yeah,
else.
I personally agree with Steve. The position should be what our position is vis-à-vis the proposed plan. And so we can make that, we don't have to take a position on history or anything
No,
like that.
no. You know, I'll say this, I take no umbrage from that. But I also don't understand why it seems like it would have been so simple. I don't know what the right word is, respectful, courteous, that you just say, we think you guys got it wrong. And this is why, and this is why we did this. I don't want to belabor it and discuss it. I just don't. That's all. That's just a personal.
No, I think, John, if I may, I think we could agree that, maybe there were missteps, right? And I think unintentional as they may be, it created a little bit of strife. But there was no malice in any action that was taken, or not taken. Right,
I personally am not questioning that. I just,
yeah,
that makes no sense, okay?
yeah, no, fair.
Hey, to get,
What makes no sense?
I think the issue here is that we didn't share it with the plan.
That it was
The
purposeful
striker-
or malicious.
Right, whether it was not shared with the planning commission that the select board was adopting a town plan for the public hearing that had changes that had not been reviewed by the planning commission.
Okay, can I just clarify, wasn't there a step where after your last public hearing, there were suggested changes?
Yes,
So it was passed, the plan was passed with those suggested changes.
right.
We then went to Two Rivers to have that incorporated, those changes incorporated.
Right, but none of the changes that were in what we forwarded were diluting the shalls to shoulds. That wasn't even discussed at our hearing. I mean, see, that's really what I guess the discomfort that people feel was that the time to have had this whole discussion and this whole philosophical thing, does it shall or is it should, was when we had the plan, and if people felt strongly about it, could have told us, and then we could have debated it. But the way things happen, again, certainly I didn't detect any maliciousness, but it was sudden, and all of a sudden the document was fairly substantially changed. At the 11,
The original document as we had it was should.
right.
And we went and changed it all to shall after beating
Yes,
it
it
to
was a
death.
very conscious decision on our part to put shalls instead of.
Yeah. Yeah, okay.
now, as a peacemaking note, I think at the very end, what galled me most about the select board meeting was you were just going to go ahead and you were going to accept either next month or the month after the modified town plan, which would be a complete disaster. So I think if you changed your thinking on it such that if you come to a conclusion how long it's going to take to get an ordinance, even if it ever happens, we should keep the town plan strong until there is an ordinance, and then quickly change the town plan to be consistent
But
with
that's
an
our
ordinance.
opinion, Jim. That's our opinion, and it was a clear opinion. When we turned the work product over to the select board, we turned control of that document over to the select board. We no longer have control of that document.
Yeah,
We created it,
alas.
we gave our advice, We don't own it.
But we're not done giving our advice.
Well, that's
Simple.
true.
They can accept it or not.
That's what
And
we
our
have to
advice
decide tonight,
yeah,
whether
is
we're gonna.
is to wait, don't change the town plan until an ordinance looks like it's happening. It's gonna be at least a year before this thing ever comes through.
Which thing, Jim?
I'm sorry,
Which thing are you?
The ordinances.
the ordinances.
Technically, I think I'm supposed to make a motion so we can discuss the motion.
Is there a
Two-part,
motion?
two-part.
I don't have the actual language, but I'd like to somehow get it out that we develop a statement that raises our concern about the changes that took place, primarily the shall, shoulds, and the like, that we believe has the potential to leave the town vulnerable pending approval of ordinances that have not been developed yet. I don't think we have to argue about they shouldn't have done it or what have
Oh,
you.
no.
But I think if we can just say that from our position of responsibility, if you will, we are a little concerned that a town plan could get approved and leave a gap of time before any potential ordinances are approved, even though, assuming, bad assumption, please forgive me for that, that the select board intends to move the ordinances forward within the select board, not with a town vote, and they know that they will get developed and then be approved so that they have that covered. But our concern, we can't control that part of it, but our concern is the time from when this new town plan is has gone through the open hearings and then ultimately approved by the select board, and the time that the potential ordinances come into play. Our feeling was that that leaves the town, I'll use the word vulnerable.
Yeah, and there's a procedural aspect to it. I mean, if we take that position at the first select board hearing, and the select board agrees, they can incorporate that in for what they propose for their second hearing. Remember, they have two hearings, we only have one.
Completely, yep.
So so that's, and I think that's the way we left it. The way, I was speaking for the commission at the select board hearing, and I think that's the way it was left. And I didn't get a strong sense from the select board that they felt that strongly about the issue one way or the other. They were willing to consider it. A big thing for them, if I understood it right, was just the timing. They just, this thing drags on and on.
For sure.
To get a hearing scheduled, all this stuff can be fixed.
I
at a
agree.
hearing. And so,
I guess I would just
Maybe
feel
that's the
that
way
part
to
of
go.
our responsibility is
It is.
to go on record and say that we want people to be aware, and it's our concern.
yes.
So you captured the gestalt. We'll put that into an actionable statement. The record is very clear. All you have to do is go back through the minutes of countless meetings that document.
I think
why
we certainly
we
have the
think
support for that.
The one thing I would want to do is, if there's a downside risk to using that language, I'd like to identify it and present that to people. If there's no downside risk, other than perhaps inconvenience, then I don't feel a change is warranted. But I want to make sure we understand.
Well, the risk, I think, again, I don't want to speak for anyone, but my understanding that Two Rivers' concern was that overly prescriptive provisions in the town plan could tie the hands of us if we wanted to have an ordinance. So, because ordinances by statute can't conflict with town plans. So they wanted to leave the town plan sort of expansion, and, so you could fit basically any ordinance into the town plan, whereas you have language that says shall, and that's your position at Act 250. You can't just you can't have the town plan here saying one thing and an ordinance saying something else. Personally, I don't think there was anything, I haven't gotten a sense that there's anybody who's proposing an ordinance that would conflict with the town plan, but, you know, I could be wrong about that. But even if I am wrong, yeah, even if,
Just checking to see if you have a fee.
no, but even if I am wrong, the town plan can be amended
Yeah.
in advance of furthering, you know, moving ahead on an ordinance, if the thinking was that there's a provision in the town plan that's gonna conflict. There's a good argument that you shouldn't set it up, you know, for these kind of conflicts if you're gonna agree with the argument to counter that is that you then have no enforcement power in Act 250.
Do you think our vocalizations have captured what you guys were thinking about the
Can you
concerns?
say that again?
Have we captured what some of your concerns are, what your underlying thinking was?
I think Dan just articulated it very well. I also just want to ask, to be recognized, what Steve had said. I had charged my colleagues on the board that we need to be right now talking with our neighbors about the bylaws that are coming and getting the town ready. That I need my 4 colleagues to all be on board to support you in the work that's coming. And so I think we're 2 things. And the third thing is that with the amendments, we felt that if there was something, if ordinances went down the tube, we could quickly amend the town plan to whatever the shoulds and shalls should be.
Yeah, that you know, and that was that.
Yeah.
If you amend the town plan to allow an ordinance, or you amend the town plan to, you know, if the ordinances fail, you amend the town plan to go back to the prescriptive way. And, you know, procedurally, it's the same thing. But but it's just what's the better way to proceed. I think I'm still convinced that the ordinance, that the town plan should be as strong as possible until you have an ordinance, or you strongly suspect that you're going to get an ordinance, and that if you're just running a big risk without, you know, with ordinances being way in the future and not knowing what's going to come out, or whether they're even going to be, or what the opposition's going to be, it's just a matter of you know, the town being able to protect itself.
I think it's degrees of conservatism, because having listened to what everyone has said, I don't think there's a bright line that says it should be one way.
No,
or the other.
and the select board hasn't taken that position as far as I understand.
Yeah,
You know, we had this similar discussion, maybe not in this detail, but that came out. But I don't think the select board has said, yes, we think it, you know, should be one or the other. They had a version, they approved it, they're going to set a hearing, and I think that probably is the way to go, you know, so we don't delay the thing.
There's going to be plenty of delays anyways.
Oh, on
But what I
not
was
on the
most,
town plan.
no, but what I was most concerned about, that the select board was going to turn around right off and accept or modify the town plan, weak as it is, which would leave us a year, maybe 2 years, open to a developer coming in with a weak town plan. I would hope that the first thing the select board would do was to figure out that, hey, wait a minute, we're happy to work with you on an ordinance, but don't take away the strong town plan that we have.
Well, let's go to their hearing and we'll take that position.
Well, right now, we're here tonight,
Yeah, but we have to,
and we're letting them know what our opinion is, I
well,
think.
a little preview, but, you know, with but I think that we should take a vote on that, whether that's going to be our position at the
there was a
at the
motion
hearing.
on that,
Yeah.
that I think captured that.
Right.
There wasn't a second yet.
What was the motion?
It was brilliant.
That's brilliant. What was the
We
motion
couldn't
essentially?
state it verbatim because.
Yeah,
Well, The clerk's supposed to write it down.
I know, but it was a length.
But he only has one arm.
Jay, essentially, and this is not what I said, but it's just, I think it captures it. The planning commission was looking at the cover of the box on a puzzle and decided to put it together one way. The select board looked at it and said, well, we can put it together another way because we know there are a couple other pieces over here that we can control. And that was the bylaws, that they can control those. They've done it in a couple ways. They've hired Two Rivers to be able to walk us through it so that we'll get a product to them. They have the control to be able to approve those bylaws and manage the gap that we are a little concerned about. They could have put the puzzle together by saying, we'll just go with all the shalls, the shoulds, we'll go with that, and then after the ordinances are approved, we'll make the edits and change it back. They chose to do it the other way. That doesn't make one right or wrong, although I think our way was the more prudent way. And that's, I think, what we're going to try to say, that's all.
That's a good way to put it, yeah.
Okay, well, actually, I have a question for Kevin. Did you state an opinion or
He's not part of the town plan.
I'm sorry?
He doesn't do the town plan.
No, I'm not talking about the town plan.
Okay.
When you remove those sections from the town plan, the shalls,
I don't
He
work-
didn't.
I don't work on the town.
He
plan.
didn't.
Right, it's very clear in our office.
no, that when
Originally,
Time to interrupt. The select board approved a version of the town plan that was presented to them
From Two Rivers.
with Two Rivers input.
you did that already.
Right,
didn't you?
but I want to be, like, I don't think a direct question to Two Rivers staff who's here on another topic
He wasn't
is
part of the town
appropriate at
plan.
this point.
I get that.
you're talking about Brian,
I'm talking about your question right now to Kevin. I don't think that's appropriate.
okay. Well, I thought, and Kevin, correct me if I've made a mistake and put any blame on you for having any input. I'll get my ink eraser and remove it right off. But I thought that information about, well, you can do this, you can scratch the shalls, was yours, but you're telling me it was not yours. Is that correct?
I make a strenuous effort to not be involved in the town plan because I'm trying to work on this thing and you know.
Oh, okay. Should we talk to Brian about this?
What you guys want to do about the town plan, you can all discuss.
Okay.
I am here for the file.
Well, you're the only Two Rivers person here, just trying to get
Well,
ahead
Brian
of
was
something.
at
But
the,
we
he
don't
was
have
at
a
the
hive
select board
mind.
hearing,
I know.
and he stated those were his
Two
reasons.
Rivers helped us when we were working on the plan.
I can give you a couple of things that are agnostic of wherever you go with this thing. One is that if select boards make changes to plans that are given to them, the planning commission shall, is the statute, give them a report that says, what do you think about those changes? So you don't have to tell yourself, should we or should we not? The statute actually directs you one way. The other thing is, the regional plan exists, whether you have a plan or not. It controls an Act 250. It's relatively heavy duty. Another thing is, when the select board warns their hearing, whenever they get there, which would hopefully not be years and years long, that's the fourth thing, is I'm not doing this bylaw for years and years. This bylaw will be done before this fall, on my part. But when they warn the hearing for the bylaw, it becomes effective. That's the way the law works.
Could you repeat that one time, please?
So when the select board warns a hearing for a bylaw, the bylaw is instantly in effect at the time of the warning. And the statute, they did that because people sometimes want to run in the door while it's closing. And so
Is there a time limit on that?
there's 150 days.
Oh,
Oh, well,
Can't just
that's,
have a warrant.
You can just go down to Blackhall and, oh, we have to vote again.
That's too many chips in your cracker.
But whenever you're ready to wrap up on,
He's ready to.
Yeah, that's a good
Well,
segue.
150 days buys you a lot of time.
yeah, it's a lot of time,
Yeah.
maybe.
I think we should move
Well,
on.
I mean, I'm glad I know that.
So can we just say that based on, I won't use his name over there because he wasn't directly part of this. That based on our understanding of what has transpired with the select board, that we will, as a planning commission, raise the issue that we've discussed tonight and make that presentation at the open hearing, and fulfill our obligation.
Did I hear you correctly, or did I misunderstand that we're obligated to?
the statute says shall, I mean.
Yeah,
I
we're
think if you
obligated to
don't,
do
I-
that.
I use the word obligated.
We,
We've used the shoulds and
Shall.
shoulds.
We could do it in writing and just
That's
submit it for the hearing.
Yeah.
I think that's very prudent. I think
Let's
it
just
reflects
do-
our work and decision.
Do that and just talk.
Let me just say one more thing. And Jake, I'm not saying this.
I'm sorry.
One of the things I enjoy most about being part of this commission is its collegial nature. I'd like us to be collegial with everyone we work with. And I don't care if we disagree, we should. We should speak our minds freely.
We shall.
And yes, we should. And we should strive to reach consensus. Doesn't mean we'll always prevail, but yeah, we should be happy in our work and in working with others.
Can I do one thing? Now that we've sort of finished this conversation, as we transition to bylaws, can Dave make his
Yeah,
2 cents?
please.
I was thinking about something. The conversation that's going on now is terrific. Both sides know where they are, and we'll go forward. The select board owns the issue at this time. When we come to a public hearing, as you've lined up, that's what we'll do. I find that I've come in and listened to you guys and come with a lot less consternation than I started out with. So the vote, the select board vote that I watched said that, simply, that they're setting a meeting. And they didn't discuss the value of should or should not as such. We recognize that it's in the language. I'm a shall guy, and I just want to be clear that there's a reason old Yankees wear suspenders and belts. And if this thing has got to be right now, then it's got to be shall, because we've all seen what happens if it's not there. And it's an object lesson. And I've probably said all I need to say. I'm really pleased with how this conversation went amongst the parties here, so. With that, I got a taco waiting for me at home, I've said my.
Suspenders and belt, that's important to
That's a
hear.
really good.
I get it.
I was hoping he was
I don't have my
gonna.
suspenders on, but I do wear them.
Before
I
you
get
leave,
it.
That's a good one. I like that.
It makes sense.
Always be prepared.
Yeah, take care.
Absolutely.
All
Thank you,
right,
Dave.
Kevin,
So
thank
did-
you for your patience.
Did you make a
I did, it's
motion?
not been seconded,
It
nor has it been
was.
voted.
I'll second it.
You seconded
Okay.
it?
well, what's the motion?
That
I-
we-
The
that we go to
motion
the
is
I would
We're
like
going
to
to
say
prepare.
that
Yeah, you,
I am glad that this discussion and what has been enjoined in context for where we're at is appropriate. I need additional convincing that passing this motion and getting it into the environment a month or two from now, where people who are not clear about where they're at for some reason will see that as there's another further sign of the fact that these two bodies cannot get together. We are together, but I agree with the content of your motion. I'd like to hear some something that would give me confidence that that may backfire on that if we put a motion, a past motion between two bodies who are thought by some people to never get along together and et cetera, et cetera, et cetera, because that's that. So can you help me on that?
The motion as I saw it was,
I think the way he worded it was good.
it's to reiterate
Yeah.
that we think the language we propose in the town plan is beneficial to the town, and we do not want to see it diluted. And to make the case, you either can make the case or you can't. And I think you would ground it in actual events that have transpired, and what well, I think we've already, the same example would give you the downside risk.
I think it was, as much as anything, was cautionary, not in opposition.
Yeah, it's not an
So
opposition.
that was my
It's
intent.
how you say it. more than-
Yeah.
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 I do hear what you're saying, though. I really do.
It should not be argumentative.
No, I think George's point is good. That's,
So do we have a motion?
Well, I believe we should put together the document and present it.
we don't have time to do that.
But do we need a motion for this?
We're just gonna go, well, we're gonna, yes, if we're gonna take a position
As the
and
planning
represent
commission, I
ourselves
think
as the
we do.
planning commission
Yeah.
at the public hearing, we have to have the planning commission has to have voted, yes, that is our position, rather than just individuals. Any individual can just go. If, we don't have to take a position as the planning commission, everyone can just go and say.
We could just show up, you mean?
That's right.
Well, here's what I'll say. Okay, so we don't have time to put together the document. I think the talking points, notes should be very clear before we get up and say anything. So we can work on those in the interim so that we present a very cogent.
Just as a point of order, I think we would need another meeting to do that.
I
And the
don't-
select board, and my understanding, the hearing is set for June 1st.
June 1st.
Yeah, so
Correct.
we don't have another meeting scheduled before then, so we have to hold another meeting.
We would
to
need
do that.
another
Or
meeting.
tonight, we can just decide.
We would need a meeting to collect our thoughts that we want to say.
I would propose that we have collected our thoughts tonight. Dan has heard our thoughts,
And he can-
and Dan can deliver the message from this planning commission with all the perspectives that we've shared.
Yeah, I don't perceive any
Disagreement.
disagreement.
Doesn't have to be
amongst us.
argumentative, just a little cautionary.
And I don't see much with the select board at this point, so
Okay.
we'll just go and say our position.
I think that's, George,
What's that?
what do you think? Does that make sense to you?
I'm not sure that I agree with what apparently is going to transpire. I really agree on the fact that something got people into this room and the issue was enjoined, and I don't see now that there's anything to worry about. But I am still concerned about
In
we need
perception?
to take care of how we come across to our people, our people, that was a term, but you know what I'm saying.
Do you intend to argue both sides?
Huh?
Would you,
I can,
Present
you know,
both sides.
yes, I can't argue both sides, but I can acknowledge the other side and the reasonableness of the other side.
Yeah, and certainly you can bring in that we're engaged in conversations
Yeah.
about bylaws, and that was our concern.
Yeah.
And then that's
That's either
even
shared or
more
it's not
facts
shared.
than some opposition, because the substance wasn't changed, it was just how it would be implemented. So,
I feel comfortable if we vote on Steve's motion to
I'm
go
in,
to
I'm
go
in
to the
George,
hearing.
I'm in George's camp on this one. I don't think, not much needs to be said. I think we know where we're going. So I agree with you, George. But that's just me.
All right, well, if
Yeah, you want,
we don't vote for the motion, we either,
Okay.
I don't think we can go to the hearing as a select board,
no.
or without, unless we have another meeting to decide.
okay,
Then we can't present as the,
okay.
I think you want a unified voice in the
All right,
planning.
Actually, Would you take over my job tonight? Because I'm leaving soon.
Can you hear us, Amy? There she is. She's
Okay, she's on. She's in.
okay.
She's in.
Who's in?
Amy Ashline?
Ah, okay.
I would like to move the motion, call the question, with the guidance that as part of our role as the Heartland Planning Commission, that as this document is moving through the process, that we should be making input, and we're making it as a cautionary statement, not a disagreement with any language that's in there that is changing our intent other than the shall, should.
We're executing on our advisory role.
Right.
And there's absolutely nothing wrong with it. How you present yourself, your tone, the words you choose, yeah, that can convey something, but I'm completely
Is that your
confident
motion?
that that will not be a problem.
I'll write something for you.
Don't, but if you're gonna write it, we have to vote on it now.
I don't have specific,
I don't see the point of writing it up.
other than I move that Dan
Okay,
express to the select board at the town plan open hearing that we add a note of caution or a word of caution about changing the shoulds and the shalls prior to any bylaw final development.
so changing
You can edit it any way you want.
shoulds or shalls.
Yeah.
Well, that's a far cry from what I thought it was going to be, what your motion was going to be. I don't know why. But that's perfectly fine.
That was the intent.
Yeah, that's
Yeah,
fine.
yeah,
I'm with you.
yeah, okay.
Do we have a second on
Let me
So who
second.
moved it first? You, SC, and then George?
I'll second.
Okay.
that? All in favor?
Right.
So it's four,
No, all in favor was,
Who said?
oh, okay.
all opposed? There you go.
It's unanimous. Oh,
Okay.
that fulfills our obligation. Now,
There's a patient man over there.
our apologies, sir.
Okay, so our work is about to begin. I emailed you all today the latest draft, which had Stephen's small comments there on the DRB. It also now has more stuff coming ahead. Should anybody see that, I've tried to label it like this stuff is coming ahead, but should people go, oh, I can't believe you already did the definition? No, that's just water for thought. So there are a few things. But tonight, what I want to discuss are really kind of general things, and it's stuck in the draft just as a place to put it, to think about. And so it's right here, but it's in the draft that you got by email. And it is largely going to be kind of very helpful for me to craft some things. And because we don't have zoning, I'm going to go over processes and names and things, and hopefully you'll tell me which way you want to turn left or right. As we've gone over previously, there's a bunch of exempt things, so they don't get a permit. Then there'll be things that get a permit, and they just get a permit. It is very similar to a dog license to me. They come in, they give you the $20, whatever the permit costs, they get a permit. It walks away. Permitted things are meant to be very non-discretionary. The administrative officer is not supposed to use discretion. So it's like, oh, I want a house. Our house is in that district. Yep. Check. is, do you know what the setbacks are? Yep, check, you know, you got the lot size, check whatever those things are, off you go. Here's the permit. My advice is that you try to keep everything in the exempt or the permitted category versus the other categories that I'm going to talk about in a second. Just because they're easy, they're the most straightforward. The next two things, and one I think you might want to use, and the other I'm going to argue against using, it is site plan. So in zoning, there are two approval processes that go to a board, typically, the development review board. The first one, site plan review, is what it sounds like. It's a review of the site plan. And so site plans typically are like, you look straight down on them, and it'd be kind of a drawing of the site. And then depending upon if you are doing visual stuff, you look at them sideways in the elevation of the site. But it shows, you know, the things. And my suggestion, even on site plan, is that a lot of those things simply go to the AO as well. Most things in site plan, first off, there are no mandatory statutory things that you do in site plan. A bunch of towns forget that because the statute suggests that you do some things, but you don't have to do them. But those are the things common in site plans. Those are traffic, parking, landscaping, lighting, signage are the big things. The things that show up on a site plan. We're going to put a sign here, there's a bush here, the parking is good here. Most of those things are really not that discretionary because you get into things like, can the delivery vehicle park off the road? Is the turning radius of the curve big enough so the truck can come in and come out? Is the parking shielded by the bushes or behind the building if you have standards like that? And so it's not really a question of like, is that behind the building or not? So a lot of the things to me in a site plan, and the statute enables the AO to handle those processes if you put that in the bylaw.
The site plan does not encompass engineering drawings, architectural drawings.
It usually does. It doesn't. You don't have to require that, but usually they are. The site plan itself is drawn by an architect or a surveyor. There's not much engineering usually in the site plan unless there are things where you have a standard that would require engineering. And the only thing that really gets into is stormwater and slope stability.
Well, as I was thinking, I mean, certainly the drawing would give you elevations, which might be relevant in some of the flood determinations.
Yeah, we're going to keep, the flood stuff's going to stay away from this. But if you had something about like, whoa, you're putting that thing on a hill, well, it'll fall down the hill. That's when an engineer might be like, yep, we're going to tell you that. The other thing, so that's site plan. And I would suggest we have a process that basically goes, okay, these things over here are going to go to site plan, and typically they're commercial or large residential. You could theoretically send a house to site plan, but it's bad idea. Bad idea in Hartland, especially. Then the other thing that goes over here are conditional uses. And the conditional use process is really meant to deal with uses that you're not sure about. So if you go, oh, banks, we'll send that to site plan because we want to make sure the traffic can come in and out of the bank. Versus, we're not sure if we like banks there. We'll have to see what banks are like. That's more of a conditional use. Where you're going to condition the use such that it's okay in the district. Your town plan has 6 future land use areas, which largely become 6 districts, and then the rules are obviously different in the districts there. The conditional uses, to me, I think they worry the people the most because they sound wishy-washy. They sound, in the way people write them and people read them, as if like you guys, or whoever the DRB is, are just gonna kind of sit there and make some magic thinking about, is this a good thing or a bad thing? And people think it gets very subjective, which it actually doesn't and it shouldn't. But I would suggest that we avoid actually conditional uses, maybe an entire decision, by going, we're not going to go there, we're just going to go site plan. To try to make the path of any proposed development as clear as it can be, so people aren't wondering what would happen to them if they want to do X out there. So those are our processes. What you end up with is you end up with a matrix. We used to do it in 10 pages, now we do it on 1 page. It's really a, can you do such and such a thing in such and such a district? Yes, no. Or, oh, yeah, you can, but you need to get site plan approval first. Houses, like pretty much yes, there are houses nearly everywhere. You do have an industrial district or an industrial land use area proposed at least. That's commonly one of the places where people go, well, let's not put houses there because that's where we put the big beepy trucks. And then everybody complains the trucks are beeping to the select board, and you go, well, you built your house in an industrial area. And they go, why did you let me do that? And you go, and so it's better to go, we didn't let you do it, can't do it. There are a few things, to me, where we've seen them enough, where there's kind of always a set of conditions that goes with them. And gravel pits is one of them.
In what is it?
Gravel pits.
Okay.
Or mines, quarries, gravel pits. And that is one of the few places where we generally write into the bylaw itself, like these are all the special conditions. You don't write it in for restaurants necessarily, or laundromats or whatever, but gravel pits kind of have their own special thing because there's a whole variety of things they always come up with. So we write about slope stability, about blasting, about hours of operation, about crushing equipment, unit.
So that falls under conditional use.
Well, what we do is we write it as a special use standard. So you don't have to send over there to the DRB for them to think about, like, do they get to operate at night and how far does the crusher be? No, we just write out everything that they would come up with as a condition in the conditional use, and it just is in the bylaw.
Because I listened to you, but I could not explain to you. I mean, I could guess what a conditional use is, but I couldn't give you the answer back after listening to you, and I'm not sure I got the bank example.
You used an example that I think is more relevant. The town plan right now says that residential structures are discouraged in industrial areas.
Okay, discouraged.
Right.
Doesn't do you anything in a bylaw.
Right. So a bylaw could residential structures in an industrial area would be a conditional use. Could be a conditional use. So I want to build a house.
You could do that. Yeah, I would say you just say they're prohibited. But
We have existing residential structures, and I'm not trying to belabor this point.
Yeah.
We have existing residential structures in mapped industrial areas.
Correct.
I own 5 acres with a house on it in an industrial area. I might want to subdivide it and build an ADU.
Right.
Right?
Yes.
That could be a conditional use residential structure in an industrial area. I'm trying to think of an example to explain.
Yeah. It more would be something like a lot of towns write a relatively open conditional use list. Some towns even write, so back to that matrix, it'll have the uses, banks, offices, restaurants, whatever the things are. Some towns for conditional uses write anything. And then they send it to the conditional use process to mold it to be something that'll survive. So, for example, light industrial is a good use. So light industrial, commonly defined as everything happens inside the box and you don't really have a lot of impacts outside the box of the building. It's not noisy, no lights, no things go beeping, whatever. It's a box. It's as quiet as a house. It has truck deliveries, so trucks are a thing, but other than that. So a lot of towns might treat light industrial as a conditional use out in residential areas. And they're like, if you can show us how you're gonna make this thing not bother the neighbors through these set of standards, we can do it. If you're gonna drive trucks here, 12 hours a day or whatever, and you need security lighting or whatever, no, we're not gonna do it. So all that type of thing. The difference, another difference between conditional use and site plan is there are 5 mandatory tests that you have to put in for conditional use. You can put in more, but you have to put in 5. And they are effect on renewable energy resources, undue adverse effects on the character of the area as proposed in the town plan for that area, effect on the bylaws, a couple other ones that I can't remember. But you kind of have to go through a convoluted process for that.
All, regardless, every town would have the same fundamental tenets within a conditional use.
Yes, yeah, you have to have those 5 and you can add more. Site plan you can kind of mix and match as you want to.
You said a big problem with the conditional use was the uncertainty.
Yes.
I could see uncertainty on the front end, but once a decision is made, it can't be taken away, can it?
No, it's uncertain. There are pros and cons to it. The uncertainty is a little bit of a black box as for the applicant of like, will I be able to do such and such? You go, I don't know. You'll have to, you're gonna have to give me the exact thing, and then we'll run it through a set of standards, and then we'll figure it out. That's the cons that I would say makes most people who are nervous about regulation extra nervous. On the other hand, treating conditional use as a relief valve by going, we're going to call out the 10 most likely things to happen and put those as a use. And then we're going to have this catch-all thing down bottom that's going to be like, hey, we can't think of everything. If you can make it fit through the conditional use process, give it a try. And so sometimes people are liking that, the ability to be like, it seems like there's a lot of flexibility down here.
But you're advocating against it.
I'm advocating against it mainly because it gets complicated, and I find more that people worry about the capricious nature of the review body more than anything else.
Yeah, but again, that's on the front end.
Yeah.
With minimal investment. And, if you get what you want, well, you fix your upside.
Yeah, and so then what we're going to do, we're not going to do it right now tonight, but what the next thing we're going to do is we're going to look at uses. And so you have a use list. Those use lists should be relatively short. And they can be pretty big boxes or pretty tight boxes. I've had towns that have had literally like, I don't even know how many, like 300 uses listed.
What's a tight box?
So a tight box would be like hairdressing.
And it strikes me as a tight box.
Right.
I know what the other is. A building.
Yeah, versus like a building. Yeah, office.
Yeah.
And for Heartland, what I would suggest is that you put sizes on lots of things. So
What, square footage?
Yeah, or number of employees or something. So if you go, okay, office, who cares where the office goes? It can't go in the middle of the woods. We basically, not a lot of people come and go to an office. It doesn't have lots of trucks there, but we're going to be making it on the main road, so it can be in rural, residential, and the village, and this and that and the other thing. And it can't be bigger than yay size.
So you said both the footprint and verticality.
Yeah.
So we would control both.
Yeah, you can control all those things. Bethel and some other towns take a different approach, which I kind of like in some ways, which is really more impact based. And that is so that, for example, they have personal service, community service, and a couple other things. So imagine a restaurant is actually not that different than an auto supply store or a large dentist's office. People come there, they stay a while, they go away. And so you go, we're going to structure a use list around places that people come and do something and go away, versus places that people don't go to ever, hardly, versus things that there are meant to be large groups of people for large bits of time. And so you can kind of write those things as blobs, and then you treat them that way. I think for Heartland, just because, you know, you're kind of in baby step mode, that we really think about houses, because that's most of what people worry about. Contractor yards, because that's the thing that comes up in Barnard all the time. You're probably a little bit similar to that. And then you probably have a lot of businesses out there where somebody's got 3 plow trucks, I don't know, wood chipper, or something, out hither and yon. Home occupations get their own puppies, so you don't need to worry about them. And then think about the things that you really want in the village and don't want other places, and the things that are fine if they're out there, mainly along main roads, that may or may not be that industrial. And mainly the thing that gets worried about those is the impact to residences, because if they're in a residential area, how do you make them not bother the neighbors? And there are standards, we'll write common standards around that. One of the easiest standards I find, Thetford uses, which is you just go, you need bigger lot. You need bigger setback and a bigger lot if you're a commercial use than if you're a house. So we're basically going to buffer you from your neighbors somewhat by just making things bigger.
And is the plan overall broad? Like, what about, I'm thinking of things that maybe I wouldn't think about. A religious building.
Ooh.
A for-profit prison.
Yeah.
A school dealing with addiction or a rehab center. Are those things going to be captured? Not those things specifically, but things like that tend to be more on the periphery.
Yeah, I would, the problems, I think you've already hit the shooting range. Yeah. So the 2 of the puppies that come up, shooting ranges and kennels, because they have impacts, and so how you deal with those is kind of somewhat set. And shooting ranges have now morphed from the Pollard example into like private military training camp. And so
We remember that one.
yeah, and so kind of closing the door on that is good. You could close the door on private prisons or something, although certain things are protected by law. Prisons, landfills, and other things, you can't just say no, because every town is
State ones or private?
A state.
Yeah, a state institution I can understand, but a private one we could, correct? A for-profit?
Private things. Data centers is now coming as a big issue, and Royalton has passed a moratorium on data centers. They're trying to figure out how to actually do that right now. We've tried to figure out if that's a rarity for here or not. We don't think it is because of a whole variety of things that happen in Vermont, but yeah, so stuff like that. I would say the biggest thing, more than anything else, is probably going to be commercial establishments of some kind along the roads. And you don't have sewer and water, so they're not gonna be that big because you just physically can't make them that big. Although, that used to be the case because people didn't have money. And you go, well, they can't make it that big because it's gonna cost them a lot. And then you go, some people have money now. And so the fact that they gotta drill a well and sprinkler the building and build a giant tank to sprinkler the building and do all sorts of things, like, okay, I'm writing a check.
Yeah, it's within reach.
Don't worry about it.
I think it was the New York Times this weekend had an article that pickleball is now receiving this attention.
Some people are driven crazy by pickleball. I mean, in a good way and other people in a bad way. Because it's the talk sound of pickleball
That was the complaint.
that drive people crazy. Outdoor recreation, as well as indoor recreation, I would think you should look at. The biggest thing that comes up in outdoor recreation, because outdoor recreation is a great thing to do in rural areas, ski centers or whatever. However, a big thing is, what about motorized recreation? I want to build an ATV, just drivable recreation thing.
Right.
Again, there's a lot of impacts to that. Can you ameliorate the impacts by going, we're going to make you have buffers, not see it and that type of thing. But mainly because of the noise. So what we'll end up doing is a use list. And again, I would say we pick probably the top 10 things that are likely to happen, put it in boxes and go yes, no, yes, no, yes, no. And then we'll think about how to deal with all the weird ones.
So this list, these examples we just said,
Yeah.
is this going under conditional or are these prescriptive?
These would be probably permitted. So
Permitted.
so you decide like restaurants in the village, permitted. We're not gonna care.
So it is prescriptive. You're already making the decision, yes, no.
Yes.
And it's either compliant or not.
Yeah.
Got it.
Banks in the village, yes.
Can I ask a related question?
Yeah.
If and excuse me if you were going to get to this, well, what about notification to adjoining landowners?
Okay. So the process by statute for all things to get a straight permit is that has to get posted at the town office, and then what we call the red P, if you've seen them around. They don't have to be a red P, it's just a thing people use. But there has to be a notice posted within sight of a town right of way, the closest spot within sight of the town right of way. And they usually just have a big red P on them. You gotta go up and look and see what they say. And that's for permits, those are after the fact. That says you've got 15 days to come in and appeal this thing. We have issued this permit. It's out the door. And so then neighbors driving by could be like, oh, and then they have to go look at it and be like, oh, no. For the site plan and conditional use stuff that goes to a hearing, because that goes to a hearing, unless you have the AO do it, but typically it goes to a hearing over here at the DRB, then all the abutters get noticed.
In advance of the
hearing.
So similar to Act 250.
Yeah. And there's interested party stuff and all that. And then the DRB makes a decision, says, yes, we approve this. That is itself appealable to the environmental court. Or it goes over to the administrator, they issue a permit, which is also appealable over there. Everything gets appealable. So that's process about that. You can put on extra stuff. You can't we've been told that you can't tighten things up. So, for example, the DRB has 45 days to issue their decision after the close of the hearing. You can't say, we're going to do it in 10. You can do it in 10, you can do it in 0, but you can't tell yourself you have to do it in 10.
The town does not provide a clearinghouse for notice. So
besides posting on the wall.
You said the posting, the town is doing the posting, right?
The town is,
The town is,
yeah,
so there's not an electronic posting?
no,
Not
there's no requirement.
No required electronic posting.
But you could put that in.
Well, things like that, like all the fee structure and stuff, I say, that's a procedure that the select board just adopts, you don't write anything off. Because like one of the things you could do is say, we're gonna give people notice as abutters for every permit. Or we're gonna make you, put an ad in the paper or something. If you have a hearing, there's always an ad in the paper, as well as the notice to the
I was thinking more of the like, this town's pretty savvy in its use of electronic media. Having to come to town hall or having to drive past and notice a posting on a throughway, it seems much easier if you've got a central place that is current.
Yeah, now, and some towns do that, they have a spot on their website and they post the permit. It's good for 15 days and then it locks and then it goes away.
We're talking, I believe, about proposed something new.
Yes.
What does a bylaw assist with an existing operation that may want to either expand or become more formal or something like that? In other words, they're already built, we've already said that's fine. What happens after that point?
Okay, so existing operations, of course, are grandfathered to continue existing. But if they want to expand or do something else, then, and they're allowed, in the matrix, if you go, oh, yeah, you can do that, then they come in and get a permit and go through that process. If they're not allowed, then it gets trickier, but you can still do it, and that's a non-conformity. So it's a thing that doesn't comply with the rules, and most non-conformities, Vermont law gives you the ability to expand non-conformities. But it also gives you the ability to extinguish non-conformities. But most towns let them expand because you go, well, Joe's a great maker of oars, and now he wants to make more oars, and we all love his oars, and whatever. I just thought of that. I don't know why. And
It's Vermont.
yes, and especially what happens with it happens with home occupations. So everybody gets to make oars in their basement right now because that's home occupation. Well, now I'm famous for oar making. I actually want to have a business. Okay, who cares? So you write that in, basically, about how they do that process. And typically what you write it in is what we call the degree of nonconformity. So you can't double the size of the building. You can't double the traffic. You do some numerical things so that people know, like, okay, this is how crazy it's going to get versus it just goes on and on and on. That's assuming that you can't just come in and get a permit for the thing you want to do.
Just to clarify, if I have a contractor yard in a conservation district,
Yeah,
pre-existing, I come in because I want to add a new barn for my equipment. I'm getting a permit for the new structure, not for the existing use.
right. You don't.
Right, you're not, so I just want to clarify.
You're not opening up the
You're not
whole
coming in for what was already there.
Right.
No, I don't want to backdate anything, but I
Yeah,
just
okay.
wanted to find out what kind of flexibility.
Yeah.
I don't, I'll put it out there, I don't necessarily deny someone the ability to be able to grow,
Yeah.
but I also understand that there might be certain parameters that they need to meet.
Right, and that's why I suggest that you always permit home occupation. Some towns don't. Sometimes say you're exempt, but I always say you should permit them because home occupations have a bound, and then there's something bigger. And that way, at least if they remember they have a permit and they look at their permit, they go, oh, it says my hours of operation or number of people or certain things. And then if I want to grow, which may be okay, I need to come in and get another permit and maybe in this district I can't, because there's always some amount of growth, it's like, no, you can't go on after that. So just to give you that idea, there are uses on that table, and then there are standards that are mostly dimensional. And so you can kind of go, okay, what's the okay front yard in the village? Not much. What's the okay front yard out there on Greenbot or whatever? More. What's the side yard? Do we care about what people do in that, or do we just say you have to stay such and such a distance from the side yard and assume everybody will cut down everything between their house and the edge of their yard? Or do you say, you can't be cutting this stuff willy-nilly? So there's those things, so we call those the setbacks. There can be height, there can be volume. You try to make it pretty clear. Norwich has a crazy thing, which is some volumetric analysis that you have to do a lot of math on.
We're not doing that.
Yeah.
Yeah, so just,
So clear.
I know you guys have said this, just touch on the bodies again.
Yeah.
The AO is a new hire, right?
The AO is a to be determined
Okay.
position.
In the review board, who comprises them?
So right now, it could be the select board, it could be the planning commission,
So an existing
could
function within the community.
it could, or it could be a
Or it
new
could be
board.
brand new.
Right, like a DRB is a quasi judicial board.
Right.
So Dan may say, no, I don't want to be on that. That's more than I'm looking for. So the planning commission wouldn't be a good fit then, right? With its current makeup. So it could be comprised of a few members of the planning commission and a few other members. Again, a to be determined thing that does not exist right now.
And the AO sounded somewhat technical in the sense that you're interpreting rules and
Yes.
regulations, maybe even laws.
Yes.
So that isn't just
It should
yeah,
be.
it looks good, go ahead.
No.
And a thing you'll see we stress in the bylaw is that the AO is really the only person that gets to do certain things. If I come to John and say, John, do I need a permit for that? John goes, talk to the AO, unless he is the AO.
I'm not.
Select board, planning, we really try to write it and we try to train, so that's the point. Because they issue, just like in Act 250, they issue jurisdictional opinions that says, oh yeah, I looked at my list and you can't or you can, or you're actually in that district, in this district, and that type of thing. And so they're an important person to know what they do. There's no requirement that they have any training in Vermont, most states.
Yeah, okay, so you don't do that.
But you could write that in?
No, I wouldn't.
No.
The state would have done that.
But
Like the training requirement?
Yeah.
yeah.
Well, or just a basic, some qualifications
That's
for the job would be in the bylaws, or you just?
No, it would be part of the hiring process for whoever that person would be.
And it's really the select board to kind of go, we're not going to get a numb nut.
And where's the appeal process going?
Where's the
Inside,
appeal? So the
inside or
appeal,
outside the town?
the appeal of anything that the AO does goes to the DRB.
Yeah, but what about that?
That would go to the E-court.
Then it goes to the environmental court. And then state Supreme Court if it keeps going.
Are there arguments for and against the AO being a town resident?
There are arguments for and against
Yeah.
the AO being a town resident.
Yeah.
Yes, and we're talking about it now.
Yeah.
I don't know if you want to take up the.
No,
There
I'm
are-
satisfied for that.
Yeah.
It's
Okay.
the AO by nature. Sorry,
You get grief.
you should not be the most popular person in town, right? Because you're going to have part of your job can be to say no to people.
So
Right.
Yeah.
John's disposal.
You should be likable.
Oh, really, couple
But you should be very fair. Like,
Be careful about using that in your recruiting.
Well, we'll be honest with them.
Yeah. The other thing, so there's all these standards, there's the uses by the districts, and it fits nicely in the matrix. The other thing that you have, because it's a unified bylaw where we're having, is subdivision, which is its own process. That to me also has a set of standards. And that can get a little more wishy-washy. And there's two big things to think about in subdivision. I would say one is a lot of towns do a major minor split. So they're like, for certain sizes things, it's just dinky, we don't care. For other things, we're gonna actually make it run through a bigger process.
What's in a subdivision? When you,
And so great. So a subdivision is literally a division of a lot into two lots or more.
okay, so we're not thinking of housing subdivisions
No.
necessarily, it's just a division.
Right, it might have the houses,
Yeah, sure.
but it might
Yep.
just be Raleigh. There are some things that we suggest you always require in there. State law basically says you have to design the roads. So if somebody's gonna put, they're gonna chop up some hillside, you're gonna be like, where's your road? And you don't need to build the road necessarily, but we need to know where the road is and we need to know the slope of that road. So it's not crazy.
But it's a private road.
But it's a private road. And most towns in their bylaws say, we're never taking over your road.
Yeah,
Like they'd actually just write that.
I mean, that subdivision sounds like a lightning rod.
We have a lot of examples in town
Really?
of areas where a subdivision may have been beneficial, right, historically.
Yeah.
Right.
It's actually, in many of our towns, I would say, where people have the most agreement.
No kidding.
Because you go, the idea is that you don't just checkerboard this field and put houses all around the field, because people in Vermont just generally don't like that. They're like, no, then it's not appealing, well, put the houses around the edge of the field, that type of thing. I would say on fields that way more than on forests, because people they just think forests take care of themselves. Like, there's trees, and there's still trees, so it's okay. And you go, well, that's actually not how forests work. But subdivisions will have a standard about the lot size, which you'll have over there in your zoning, and then they'll have some more standards usually about the road, and those are the big things. Stormwater, but you don't have subdivisions that have sidewalks and lights and the whole shebang, like they do in large parts of the world. And especially your, 5 lot and less, because they won't trigger Act 250, that's where you want to see stuff around that. And most towns, what you want to do is you want to make sure they're safe, and that you're not impacting fields and forests. And again, you may go in our more rural areas, we don't care, but in that remote area, the screen of the map, we care, and so there's a standard for subdivision over there that doesn't apply over here. A lot of times we suggest that the standards apply at certain lot sizes, because you go, who cares if they cut up 2 acres of ag land? It's already a 2-acre lot, right? Done.
Are there consistent standards for safety provisions?
There usually are about the road,
Yeah.
and the main thing being the fire department.
Yeah,
on the
fire
road.
department.
Right.
And so that has to do with the slope of the road and the width of the road.
Yep.
The slope of the road, because you don't want the fire truck to not go up it, and the width of the road in that if you're doing a tanker shuttle, the trucks can't go by each other. And so a lot of what towns do on that thing is they go, the standard is you will get a letter from the fire department going, they're good. And you don't even write a standard, you're just like, fire department says good to go. Or you actually write a bit more of a standard in there. And there's, that's where we have a bunch of numbers, and we give you the numbers, and you go, it seems a little steep or not steep enough.
How does the fire department get notified? How do they know what's cooking?
For
I don't
ones,
mean that literally.
yeah, for ones where that is, you go, I see you're applying for the thing that meets the fire department, and the AO goes, not complete, go to fire department. And then sometimes there are other things, but that's the usual one.
and everything's identified, do we have everything identified? I'm just thinking, it's the population of this town, and all towns, ages. It's hard, I mean, an ambulance stopped me. Hey, do you know where this house is?
Oh, you mean numbered?
Yeah.
Yeah, so we continue to work on getting the retroreflective signs out. You should have two of them, right? On your structure and out.
Okay.
And again, we have areas in town or roads that were not subdivided, but kind of
Yeah.
divvied up as it went, that are confusing.
Yeah.
Very confusing for emergency services.
Yeah.
Subdivision regulations would prevent that from
Okay.
being the case in the future.
The first few years of the Paul North development up by me, if I was outside in front of the barn, the fire trucks are starting there, and I'm saying, you're a mile and a half away, it's over here where you need to go, because it was brand new and not marked.
So, one of the big things on subdivisions, besides, fields, forests, maybe wetlands, it has to do with septic. And towns are enabled, and I suggest that they really do, to say, you get your septic permit before we give you our permit. That's one of the few chicken and egg things where you go. Until you have that, we're not giving you our permit. I also suggest that towns always require the uses of the subdivision. This is a residential subdivision, I'm not building houses, but I'm building house lots, versus you don't know what's going in here. So they either tell you the uses, or they don't get a permit for uses, is how I suggest subdivisions work. And so they go, I don't know, I'm just cranky Al, and I just want to chop up my land and sell it. I have no idea what the next person's going to do. Stop asking. You go, great. Subdivision permit. Part of the subdivision permit says you apply for no uses. No uses are allowed on this property forever until you get a subdivision. Until you come back and get a new permit. And that, by the way, and that applies to all the lots. And we can require, as part of our permit, because you didn't tell us what you're going to do, we can require that you reconfigure all of these lots in the future if you want to do anything.
I imagine that would take down the value of the subdivision.
Yes, and all the crazy people pick that subdivision permit. But I've seen many people.
Well,
yeah,
I
that's the
think,
thing.
but you see, a permitted lot is worth more than an unpermitted lot. So in other words, you're not buying a lot sight unseen.
Yes.
But you're buying a lot that the town may go, oh.
It's already approved for a house.
There is no experience in Heartland about what you just said, about an improper subdivision.
Right. Yeah.
There's for that matter, there's no one in Heartland that's going to be deemed not in compliance, because there's never been any compliance standard.
With existing stuff.
Yeah,
now,
exactly.
If they didn't get a state subdivision permit, because all lots get a state subdivision permit when they are created. Now, in Act 250, all lots get what's called the potable water and wastewater supply permit. If they went and made a lot recently, and they put something in the ground without a state permit, they have an illegal lot. That is not grandfathered because that was not legal.
How recent is recent?
Yeah,
Since it was required by the rule, not anything you did, but the state.
right. Yeah, I can assure you that if we drove across the floodplain in Heartland right now, we would find illegal structures. I can almost guarantee it. We have floodplain regulations.
Oh, yeah.
Yeah.
Usually what you see is a structure, so old things, have mystery systems, right? Mystery wells, mystery septic, that's okay. And then you for 10.1 acre lots, they were exempted from state potable stuff, so you could kind of be crazy and bury your car or whatever. Since then, when you've been required to do one of two things, either a deed notice that says can't do anything here, or a design. But that design is for a 3-bedroom house, and then you go and build a 6-bedroom house. Can't. Those are legal. So those don't get grandfathered. And so if people did something they shouldn't have, they're in a pickle. I just want to check on, I think that's
Hey, you say that, they're in a pickle, but what is the enforcement mechanism?
so the enforcement mechanism for that is because that's not your permit, that's a state permit.
Okay, so it's the state of Vermont.
Yeah.
Got it.
It is, I've dealt with people who stumbled into that, and that they weren't the one who did the illegal thing, they just bought it. And so they're like, I used my entire life savings and bought this trailer on a lot that the person before me did not get their septic permit, and they just did this thing. I had no idea of knowing because I did not hire a title attorney, and am a dumb nut, but this was the cheap, easy thing to do, and now I own this violation. In Vermont, if it exists for 15 years, it's done.
They waive it. Yeah.
Oh, is that, that I wasn't aware of.
Yeah, there's
Holy cow.
as a zoning violation, as a wastewater violation, no, but as a zoning violation. Yes.
Oh, I see. So you separate those two issues.
The only other thing I want to talk about real briefly is, not to get a solution, is short-term rentals.
Third rail.
Short-term rentals, because they're a house, they look like a house, but maybe they don't function like a house. You can regulate them. You can decide, like, we don't care about them by district. Again, everything can get different by district. They can't get different within the district. That's the important part. But you might go short-term rentals in the village, great. Short-term rentals in forest, not great. However you want to do it. You don't have to regulate them, but you might. The other thing that we're very pro of, that I think gets a lot of people willy-nilly, and I think Harry's in Woodstock right now, catching fire for, is multifamily structures. And so we try to suggest to towns, so first off, a house, an accessory dwelling unit to the house, or duplex in the house are all allowed. You can't not have those if you have houses. But a triplex is not protected by statute or a quadplex or whatever. We suggest to most towns that you permit at least 3 and 4 unit structures. Because the difference between a big house and a 4-unit structure is indistinguishable from the outside. Except there's 4 cars in the yard versus 1 car in the yard. And from a traffic analysis, 4 cars and 1 car are the same damn thing. Unless you're in Hanover and you've been reading the paper, because they're all in the snitch about 1 more apartment in a building that was going to drive everybody crazy. That's the thing that but from a housing perspective, we say it kind of looks like a house. So really the thing to me that addresses people's concerns about that are rational concerns, are the bulk of the building. And so maybe we have more noise because we have 4 families in one house. Of course, maybe there's a large family in one house. We don't care about the noise, so how do we worry about that? But I think screening, lot size, things like that, and bulk parameters are ways to get at the actual concerns about multifamily out there.
That's interesting because we spent a lot of time thinking about housing density.
Yeah, how location dependent, can it be or should it be?
You can make it by district, yeah.
That's what we've done in our
Yeah,
town
because
plan.
typically the whole idea is way out here in the boondocks,
Yeah.
would rather you have nothing, but we're going to do houses. And so we just don't want lots of traffic, and we'll do that by not having lots of houses versus having houses of quadplex. What what I think when most towns, and people don't say this, is most people think of rentals as low income equals bad people. And so a quadplex is by definition full of bad people, compared to if I built that same house, but it was a giant house, and a rich person came there once a year, somehow that's great, whereas the other thing is bad.
Yeah.
Hopefully that's changing.
But from a land use perspective, it's a big box, who cares? But it sounds like STRs is going to be an issue. Signage and lighting, I try to hit a little bit. They get very touchy, but there are ways to do that everybody can understand, so that you don't have lighting in particular.
What do you mean by lighting? You don't mean lighting on a sign. You mean lighting, period.
I mean lighting, period. And the best thing we use is we use fully cut off shielded fixtures, is what we say. So that is a fixture where you don't see the light bulb. So the light shines down here on the lot, but if I put that thing on the side of my house and I shine it at you, you can see the light bulb, with the exception of motion censored security lighting. So it goes off. But I would say as people move to Vermont and they're a little more urban, they like to sometimes really just put lots of lights on.
Light it up.
Light it up. And you're well within your rights to go. Nope.
Okay. That's
Dark
interesting.
sky doesn't.
I was going to say, I mean, perhaps one of the great things about living here is this real darkness.
Yeah. Jay.
Is there any statistical data about towns that never had a land use ordinance, that they changed your mind and came back and decided to have one?
The only thing that we just studied now many years ago with the law school, and we looked at tax rates. We did this for Sharon, because they're like you, they don't have standard zoning. And we looked at towns that had tax rates and that had zoning and didn't have zoning, to try to see if it affected the tax rate of town. And the general deal was that if you didn't have zoning, your tax rates tended to be slightly higher. That the zoning actually made your tax rates slightly go down.
Why is that?
Yeah, I got to think that one through and see what causes that, what results in that.
I don't know. And again, we were picking smaller towns, so these towns weren't towns that like, oh, we had to have a full-time fire department or a full-time police department. They're Sharon-ish size. We thought it probably had to do with road budgets, because you did not have lots of people going hither and yon and then going, oh, now we got to upgrade that road that used to be a road to nowhere and is now a great big road. We got to spend all the money.
When you go through all these examples that you mentioned tonight, I think if people in town were to hear all those, and they would throw their hands up in the air to say, oh, geez, if there's zoning in town, that X, Y, and Z is going to happen, and I'm going to have to do this and that. I must say, I have a dim view of what the reality is as far as this town.
Well, that's why I use the dog license, because as a matter of practice, that really is about what it should feel like.
That's what, you have to sell that.
Yeah, oh, and you have to sell it too. And go, this is what it feels like, guys. You come in, you give the fee, you walk out, you stick the thing in the ground, 15 days later, you're off to the races.
Couldn't be easier.
Well, for like 99% of the development, that's what they do.
Yeah.
That's where the subdivision, like especially the minor subdivision, you go, okay, you're chopping off a small lot, you're not in the middle of some special place, it's like not on the mountaintop. Ridgeline stuff, I think that we have a very basic ridgeline provision that we can use.
That's an easier sell.
Yeah. Barnard's considering one, you know, Concord has it, Woodstock has it. Theirs are more complicated, but we tend to do a relatively simple one.
But
that
to
all
Jay's,
about safety.
to Jay's question, though, just from your personal knowledge or experience, like what, do you know a town that is in the last 10 years has gone from 0 to ordinances? And, you know,
In our region, let me make sure. I don't think so in our region.
South Royalton.
South Royalton has talked about it, like you all. Sharon is talking about it. Pittsfield has tried it. Berkshire did it, but it wasn't in the last 10 years.
Pittsfield doesn't have zoning? No.
We've had a lot of towns update their bylaws and stuff. Fairleigh did it, like a big revamp on theirs for sure, which was pretty aggressive. Yes, we haven't had any towns add it in entirety.
Doing what we're contemplating doing.
Yeah, we've had some towns try.
Do you have examples in the state that we could, recent examples that we could use as reference?
I can ask around. There's a DPA listserv that we can ask questions like that.
I don't know if that would help us, but.
Yeah.
I think it's a lot more work than I realized. I don't have a negative reaction to what I'm hearing. It sounds reasonable, it sounds fair. But putting together all of that infrastructure work, I mean, that's a very reasoned process, and it's going to be like the damn plant. Some people are going to say, no way, and some people are going to say, that's a great idea.
Yeah, I think the hard part will be is something new. It won't be 3 pages long, you know, it'll be, I don't know, 30, 40 pages long. It'll be some size. But, you know, it's kind of like opening an auto repair manual. You go, well, what do you do in your car? And you go, well, pretty much I change the tire. You go, well, that's the page you need to look at. The rest, you're not going to deal with. Yeah, it's big, but most of it doesn't apply. And that's why I try to write it from beginning to end about the things that apply, so that the things that don't apply, you just don't get to and don't worry about.
You know what we could do? I don't mean to take up more of your time. I know you want to go. I think in town here, if there was a list of people that were self-employed in their own little businesses, you know, that didn't want anybody to say, oh God, you know, you need to make your driveway wider, or whatever it happens to be. I'd like to understand what the business build-up, local business build-up is.
Yeah. So homework is, because you guys know your town very well, think about existing things that people have, like, oh my God, I never realized Fred had an auto body shop over there, whatever. And think about the scale. Think about how far back is that from the road? That looks like a good distance. Why did that house bother me and that house didn't? Oh, it's because they cut down all the trees, or whatever the thing may be. We're not going to do color. We're not going to do design review. Ain't going to happen. Not doing that. And then, of course, think about any nuisance stuff, like you go, that drove so-and-so crazy. Why did it drive them crazy in terms of impact? Because of noise, or somebody saw it, or whatever the thing may be. So think about those things, because that's going to drive us when we write those numbers. We go, is that 35 feet or 45 feet? Do we care about the height or not the height?
When I hear Jay's question, I thought I had asked something similar to that earlier about existing. If we're talking about tempering down the anxiety or what have you, if someone is in an existing, I'll use quotes, business,
Yeah.
and they have a driveway that's 15 feet wide, and we decide that they need to be 20, we can't go back and tell them, oh, by the way, you have to change yours.
Yeah.
So their worry can be set aside.
Maybe, because it goes to material change.
Unless they come and want to change,
Yeah.
then they go into the new. I get that.
Yeah.
But they wouldn't have to make any substantive
Now,
How
or
about
any
if they wanted to
change
sell the
if they
business
existed.
as is?
What?
How about if they wanted to sell their business as is and someone else just comes, a new owner comes in, would they have to meet the requirements?
All of those things run with the land.
It follows the land.
Okay, fine.
That's the term we use, it runs with the land. So it doesn't matter that that's Fred, they're selling it.
How was Act Two, I'm just curious now, like Act 250, there's a lot of stuff that, that was pre-existing before Act 250 came in, a lot of stuff in this town.
Right.
And but if those people just sold their business, that they still not, the new owners are not subject to Act 250.
No.
Okay.
The thing that comes up in Act 250s, because my neighborhood of quarry business, is intensity of use. And so sometimes you go, well, we always hauled 8 truckloads of stone out of there. And you go, always? Like, now you want to haul 8 truckloads? Nobody remembers you ever hauled. So sometimes you get into that, like, how do we establish that?
so it's the arbiter of the rules and of the change, which is internal to the town, right? It's the AO and the review board,
Yeah. And
and then the courts.
Okay, so those are the kind of parameters, and I'm going to start kind of putting in things, and then probably going, oh, that's a little too much and taking them out. But the big things will be trying to put in a good amount of flexibility while being clear. And think about short-term rentals, because there are several places we can put boxes on short-term rentals. In terms of number, in terms of size, in terms of ownership.
When you streamline though, would you do us a favor in some cases, sure, take it out, but in others say, my recommendation is this be removed so that we can discuss it with you. Because it's a lot harder to put things in after the fact than take them out.
Yes. At this stage, yes.
If you, if I'm hearing you correct, John, when you put this together for us to go into edit, to comment on, and what have you, if there's something that you think we should consider, don't just eliminate it, because well, that's a little extreme. Keep it there so we can say eliminate it.
Well, and then you can also tell your neighbors, we cut out all this stuff.
Yeah,
I'm not that far down.
I'm not gonna be talking to my neighbors.
I think you should say some of our neighbors.
You want to have a cheat sheet?
Yeah.
I think what John was saying is that it's helpful that you're going to give us a target that we can look at, but make that target sufficient so that we have questions enough to say, do we really need that?
Yeah, I'll try not to self-edit it down.
Yeah,
too
okay.
Okay, that sounds,
Thank you.
it's gonna be interesting. At the very least, it's going to be interesting.
Yeah, and think about things, like data centers were on our mind, and now we're kind of like, do we really need to? We think in Vermont, grid-connected data centers would have a very hard time. It's the non-grid connected data centers that really are the pickle, because the big squeeze on data centers is what you're going to do to the grid, and the Public Service Department has to approve all those grid changes. What we're seeing right now, just there's one in Utah just got started in permitting, one in Michigan, it was just going through. But the one in Utah is a 40,000 acre campus that will use twice the power that the state of Utah uses.
And all the water.
Yeah.
And
So-
they're building their own power plant, so they're
Right.
not like, don't worry about the grid, we got it. And you're like, oh, yeah, the one in Michigan is a 21 million square foot building.
Jeez.
It cost
One
16
decade ago,
$16 billion.
data centers were being chased by every community. Northern Virginia
Yeah.
went bonkers trying to get them. A decade on, nobody wants them. And the risks, I mean, you think about it from the engineering nightmare.
And what do they all look like when you're driving through Northern Virginia?
Yeah.
Do you see them? I mean, I haven't been down there.
I'll tell you what, driving through Pennsylvania, on down into Virginia, you begin to see one huge warehouse data center after another. Now, a lot of it is for logistical reasons, meaning trucking.
Yeah, I've seen them in Pennsylvania, the like trucking terminals.
Yeah.
But the data centers must just be honking.
Any further business to discuss?
I move we adjourn.
Do I hear a second?
Second.
Meeting is adjourned at 8:40.
Thank you, Kevin.
Thank you, Kevin.
Thank you. Yeah, that was really,
Sorry we kept you so long with the
Amy,
preliminary stuff.
good night.
Night, Amy.
Amy's been out there before.
Yeah.
Yep, yep.
She's been good.
She's gone.
When's the next one of these sessions?
First,
Oh, when's our next meeting?
it's first
First,
Wednesday. in
first
June.
Wednesday.
All right, which would be,
I think
And
it's
I
the
can't
third
be
or
here.
fourth.
well, the first is select